and I'm delighted that you could join us today for the Crisis Management for COVID-19 Week 14. Has this been going on forever? We're going to give you a great legal update and tell you what regulations have changed and so forth over the course of the last week. But we're also going to talk to you about workplace culture, and I think you're going to find that really interesting. So a little more introduction as we move on through these slides. We've got a great team of folks with us. You all know Jim Morris with Morris & Morris. He's been sticking with this, and that boy, he's responded to a lot of questions between sessions during the course of the week. And Jim, we so appreciate your talent and all your dedication to this. We also have another special guest today. Michelle Hollingshead is here, and she's an executive coach, and she's a team and leadership development culture change person. And she is really a local treasure. It's amazing to have her talent right here in Lexington, Kentucky, and Central Kentucky. Michelle designs and delivers innovative leadership development programs for companies literally around the world. She's been doing this since 2009, and she's an award-winning teacher. She's a member of the faculty at the they're a global leadership and conscious business transformation. So she helps companies make this transformation when they're trying to make a big change in their organization. She works with clients I mentioned all over the place. You know a bunch of them, like Procter & Gamble and Microsoft and Lexmark and Cisco and Cigna. I call her, and I tell you what, you never know. She answers the phone. One day she was in Peru. Another day she was in Canada. She's around the world, but she also has 2 kids right here in Lexington, and she likes being home. So we've got her working for a number of Central Kentucky and Kentucky companies. And I think you're going to get a kick out of what she has to say about how we handle culture during this time, because our cultures are under challenge right now, and how we respond to COVID-19 is going to matter. It's going to make a difference whether people want to be with us or not be with us. And I'll give you some more on that as we go. But and we also, Allison is here to take questions. Autumn is going to be assisting her with that, and Chase has got control of all the technology. So let's rock on and see what we've got a great day for you. I mentioned we're going to do the legal update, and we got the crisis and workplace culture. I want to say a few words before we go any further. You know what? I talked to you last week about hope and how important that was. And I tell you what, I've had a rock your world kind of week. And hope has played a big, important part of keeping me positive. Last Tuesday, I had dinner with a very close friend, healthy as could be. We did an outdoor dinner at a place that had lots of space, and we were wearing our masks, and the servers are wearing their masks. But on Wednesday, my buddy went in to get a COVID-19 test. He did it because he was getting ready to travel, and he thought, I want to know how I am. This guy keeps his distance. He doesn't visit with anybody. And by George, he got a positive response. So on Thursday, he let me know it was coming, but I got the dreaded call from the health department, because if you are found to be positive, the health department will contact you, and they'll find out who you've been with in the last 48 hours. And I'd been with him within 48 hours. So I am now restricted for 14 days by the health department. And I got to tell you, hope plays a big response in how you are a big part in how you respond to this. So I actually went out and had my own test on Thursday. My wife and I both did, and thank goodness we were negative. But now we're keeping close quarters, and we're confined to our home. And fortunately, we've got good friends that are helping us out with things. But we have not had any symptoms, and we're on watch. I may have a second test today, and if you want to know more about that, call me, because there is a way to work this thing that's, I think, helpful. But I want to know I appreciate all the support I'm getting from my employees and friends, and it really brings it home when you get that call from the health department. So I want you to know I have absolute total respect for people that wear their masks, because I've been wearing one always since way back in February, but not everybody does. A lot of people think it's kind of a joke, but you just never know when it's going to slip up on you. So wear your mask. Let's press on, because we've got a great day. Jim, I'm going to pitch it over to you. Oh, one more little announcement I got to make. We tallied up the contributions from last week, and between Hanna Resource Group and Morris & Morris and Kimi, we had a total of $2,660 that we've donated to these 4 different funds. And I know they appreciate it because they are fighting this battle every day, helping to do the extra things to provide food for children and families, and coronavirus relief in a number of ways, helping people with jobs and so forth. So the mayor is really doing a great leadership job on this, and we're trying to follow her. And so I know a lot of you committed to do some things, and we still owe you a reminder letter about that. So that's going to go out in the next couple of days. With that said, I will pitch it over to Jim, and I see we're already getting some people signed in with questions. Jim, take it away and tell us what's the latest.
All right, so good morning, everybody. Just wanted to cover a few things. We're going to try to keep it a little shorter. If you have questions, you can post them. So let me go ahead and get into this. So we have a couple of things that have happened in the last week, and yes, this is brand new. I know I covered the EEOC last week, but they have a new update for us for this week. You're going to see a lot of this happen, and you need to stay on top of these types of things. Now, I want to let you know the legal update this week is a little bit of a merger. I'm doing some COVID, but I'm also going to do just some legal, because we're into a new type of situation where we really need to start focusing on how we open, what we do, and so on. So the first one is the EEOC update. So the EEOC has come out with a direction this week and said not so fast. And basically they've pulled the reins back on COVID-19 testing, which is kind of scary, but you need to be up to date. The concern this week is this is one of their frequently asked questions. It was posted on the 17th of June, but they don't say effective today, this is what we allow or don't allow. It literally says you can't do this. This is an illegal test. And the question was this. CDC said in its interim guidelines, now these are direct quotes, I did not change anything because I want you to understand how serious this can be. CDC said in its interim guidelines last week that antibody test results should not be used to make decisions about returning persons to the workplace. In light of this CDC guidance under the ADA, may an employer require antibody testing before permitting employees to re-enter the workplace? You'll notice the date there is the, whoops, sorry, let me go back. My highlighter to work. The date is June the 17th. The answer they gave was no. An antibody test constitutes a medical examination under the ADA. What's ironic about that is every test that they've been allowing you to give, including the temperature, as I told you, week 1, week 2, week 6, all the way through, every single test you give during the COVID-19 pandemic is an examination. So saying that this is a medical examination under the ADA doesn't really make sense. But then they go on to say, in light of the CDC's interim guidelines, that antibody test results should not be used to make decisions about returning to the workplace. An antibody test at this time does not meet the job-related and consistent with business necessity standard for medical examinations or inquiries. This is a huge change. It has gotten zero press, it's gotten zero information, and I've not seen any. I've seen a couple of employment lawyer groups, large, huge national firms that posted a little, hey, there's a new update, but nothing else. But the problem is this. We were told all testing was okay, and so people started doing the testing to allow people to go into the workplace, and as I kept telling you, the CDC controls. Well, the CDC came out with its guidelines saying, no, let's not do antibody tests. Okay, this gets a little bit into genome and so on, but the GINA Act, if you don't know what that is, you're not allowed to have information related to anybody's genetics and so on. But the antibody test was being used by certain organizations, and now this basically says you can't use it, but the scary part is it doesn't say starting June 17th. I'm pretty sure the EEOC will have some leniency for people who did this during a time when the CDC said, we don't care, go do whatever you need to do, but just wanted you to know that update because that gets a little scary. This is a frequently asked question. It's the only one they had this week, so it is their main focus. Then they say this down here, and I just want to make sure everybody understands, antibody test is different from a test to determine if someone has an active case of COVID-19. So if you're unfamiliar with these, the antibody test basically said, hey, you've already got the protection built into your system and you won't get this or you're unlikely to get it. The virus test says you currently have it. So those are the two different types. So that's the update on the EEOC. Next, on the PPP. The PPP has come out with some guidance, and this is scary because a lot of people don't like their private information out in the general public, even when you own a business, whether you own a business, what you're doing with the business, and so on. So I put the notation at the top. This came out on the 19th, which was Friday, I believe, and the notification is that the SBA and the United States Treasury came out with the following declaration. This is a direct quote from top to bottom, and I'm going to read it because you all need to know what this means. The SBA will now disclose the business names, addresses, NAICS codes, zip codes, business type, demographic data, nonprofit information, jobs supported, and loan amount ranges as follows. So if you got between $150,000 and $10 million, everything related to your business will now be out there. I believe that there's going to be some lawsuits related to this because there was no information about this being part of your loan when you applied for your loan. There was no indication that you would have your business, your address of your business. A lot of people may not want to have their business address listed, but having everything listed, including the jobs that are supported, the nonprofit information, which if you're a for-profit wouldn't be in there anyway, but your demographic data, your business type, your zip code, your address, everything's going to be out there. If you fall within this, which are, as they say down here, 75% of the loan amounts that have been approved fall within these categories, you may want to contact and find out from your bank precisely what they believe is going to be done. There's no way to put the cat back in the bag. There's no way to protect your interest now, but that's a huge sea change as well, and I've heard nothing about it. But when the department, the SBA and the U.S. Treasury after the fact say we're going to start releasing all of this private information related to loans, that's a pretty serious thing. And so if you want to know where to find that, I'm dragging this on the, dragging this on the screen, put it on the wrong one. Sorry for the back of my head. It's at the home.treasury.gov website. Take a look at that. If you need that information, that's where you'll find it. So that's the update on the PPP. With the Flexibility Act, they decided, okay, you're going to change it from 75% to 60%. And by the way, they did say originally that that was going to be a cliff. We talked about this last week. It's not a cliff, meaning you can go above the 60% of not being, or below the 60% being payroll, and you can still get your loan. It's just part of your calculation as to what can be deducted and what can't. So that's the good news. That's the buyer beware notification. Next, got a couple of updates on legal. The first one is a COVID. The next two are not. So this is the end of your COVID update, and then you've got Supreme Court updates. So first, United States District Court, if you'll recall a couple of weeks ago, I think it was week 12, maybe week 11, I raised the issues, the legal issues that I thought you'd be dealing with now with regard to the COVID-19 and the fallout. And one of the big ones that I expected people would start needing assistance on would be enforceability of non-compete and non-solicitation agreements. because of the COVID-19 furloughs and so on, I had the feeling that we would have issues related to whether or not people would be able to enforce a non-compete, how many people would try to jump jobs, whether people would chase their old employees, and so on. So here's your update. This is the very first one. If you're not familiar with how federal systems work and how state systems work, this is basically what you're dealing with. Most non-competes will end up in the federal system because companies are companies from different states. You may try to file it in state court, somebody's going to remove it to federal. Once it's in federal court, you basically have three levels of court. You have a district court, which is where you file your case. You have an appellate court, which handles a multi-state area. For our area here, the Sixth Circuit covers Michigan, Tennessee, Kentucky, and Ohio. So those different states, it depends on where you go. It takes a while for a law to make it, or a case to make law through the middle levels, which are the Court of Appeals, and up to the Supreme Court, which is the next level above the circuit court. So you go district, circuit, Supreme. District is your local. Each state has either 1, 2, 3, 4 divisions, Eastern District, Western District of whatever state, or Northern, Southern, so on. Not to get into a whole lot of it, but I want you to understand this is not binding upon us. Why? First, it's in Pennsylvania. Second, it is only one judge's decision. Third, it has a long time before it would make it to the circuit court. It is influential. It can be utilized in different district courts, so I could use it in the Eastern District of Kentucky or Western District. It's not binding upon them. So, here goes. In the Eastern District of Michigan, Eastern District of Pennsylvania, there was a case filed against an employee who was furloughed. If you go back about 6 weeks, I talked to you about the fact that furlough, layoff, fired, termination, I don't care what terminology you use, they all mean the same exact thing. There's a separation in employment that allows people to go get unemployment. If you separate employment, then you have issues related to enforcement of various contracts. Now, this person had a contract that specifically, let me see if I can point that out. This one had a non-compete that, quote, did not apply in situations through no fault of the employee that the position is eliminated. This employee tried to utilize that argument to get past enforcement of a non-compete. The Eastern District of Pennsylvania agreed. But the main thing that's highlighted on here is for you to see in red. The public interest, this is the judge's rationale, the public interest did not favor an injunction prohibiting competitive employment when the United States was facing the highest unemployment rates in more than 7 decades. So, a lot of you on here represent companies or are the companies that have non-competes, and you have people laid off. If they have not come back to work, or if there is going to be a challenge, now would not be a smart time necessarily to challenge non-competes, but if you want to bounce out of your job and go to a different one, now might be the time to do that. Not saying that there's any guidance yet in the Eastern District or Western District of Kentucky because they have not yet posted any, but this decision, I would suspect that the general economic conditions are going to be a factor in enforcement or non-enforcement of non-competes. We went from February, where I basically could walk into court with a non-compete, show how it's valid under a specific state law, and we would get it enforced, to now being in a situation where basically I'm not sure you're going to get it enforced anywhere because states are going, or judges are going to say, you know what, we need people working, and we're not going to stop somebody from working when you laid them off. They can go get a job, they can go out and compete. This one, if you pull it up or wanted to look at it, I think that the attorney for the company really did a disservice for the company. I hope they're not on the phone here. It's a Pennsylvania case. But they didn't do their homework. They alleged competition. They alleged privacy. They alleged proprietary and trade secret, but they never identified anything to the court that the court could sink its teeth into. So I don't think it has a whole lot of weight with regard to confidentiality. I've told every client I represent on a non-compete that we'll agree not to steal any confidential trademark, trade secret, and so on. As long as you're doing that in this economy, I think that you're probably going to be okay. So, the next issue we're going to cover are Supreme Court cases. I wanted everybody to be alert to the Supreme Court case update. So, first one. LGTBQ plus protections have been clarified. This is something that I actually have a whole lot of experience in because I used to do all plaintiff side, and now I represent companies to try to protect them from engaging in wrongdoing. I actually had the first case in Kentucky of trying to protect someone who was a lesbian at the time in the 1990s. And my argument was that Title VII and the Kentucky equivalent of Title VII prohibited discrimination on the basis of gender. And her gender was being used against her because if she didn't like someone of the same gender, she wasn't being treated identically to someone who liked a male. So it was because of her gender that she was being discriminated against. Ironically, and I won't say the name, judge that became a Supreme Court judge for the justice for the state of Kentucky rejected it on the last day of their position at certain county court and rubber stamped it with a one sentence that said this person is not protected under Title VII or KRS 344, which is our equivalent. And we didn't have the financial resources to keep chasing it through past our state to our federal. It got rubber stamped at the state level because this person was on the Supreme Court. So it was unfortunate at the time. It took 23 years, but the Supreme Court has now addressed it. The reason why I'm addressing it with you, you need to immediately address this among your managers because this has immediate impact. It's nationwide. It governs Chapter 344, which is our state equivalent, and it is the law right now. It has literally changed everything. Prior to Friday, or I'm sorry, this is on the 15th of last week, so prior to the 15th, you could engage in discrimination with regard to someone's gender under federal, not necessarily under state or local, and we tried that because Lexington had a local ordinance and we got rejected on that as well at the time. You can no longer do that. You need to change your policies, your procedures, you need to talk to your managers because a woman's gender, an individual's gender includes their gender preference. So if someone falls under the LGTBQ plus category, you cannot take any adverse action against them under the Supreme Court's ruling. The red line here, these two are the critical aspects. One, Title VII's ban on sex-based discrimination prohibits discrimination based on sexual orientation. They then go on to say, when an employer fires an employee for being homosexual or transgender, it necessarily, intentionally discriminates against that individual in part because of sex, in violation of Title VII. So the part that I put in here is it extends that prohibition to state and local jurisdictions that were silent on the topic before or explicitly allowed for such discrimination. That would include the state of Kentucky because we were silent. It now says you are bound. It is a gender discrimination claim. It is a significant case. It affects everyone who runs a business, so I wanted to bring that into this discussion. The last one, DACA. I'm not going to spend a lot of time on it. I just want to make sure that you all understand that this is a temporary address by the Supreme Court. The Supreme Court, everybody last week, all kinds of announcements about how this settles DACA. This didn't settle anything. The Supreme Court rejected the action of the administration based solely on the fact that they thought that it exceeded the ACA, the Administrative Act. They did not follow appropriate procedures. So because of that, it got rejected. I highlighted the important part here. It says, we do not decide whether DACA or its rescission are sound policies. The wisdom of those decisions, actually that is a direct quote, I believe, is none of our concern. We address only whether the agency complied with the procedural requirement that it provide a reasoned explanation for its action. Here, the agency failed to consider the conspicuous issues of whether to retain forbearance and what, if anything, to do about the hardship to DACA recipients. This is going to come back up to the Supreme Court, or it will be addressed by Congress. Honestly, I'm surprised at the ruling because it was an administrative action taken by a prior administration, and a new administration has the ability to set aside executive orders. It's really scary what's going on because they're literally taking press sound bites and certain discussions during open forum that the secretary of the particular commission made comments, and they're using those comments to try to say, well, this is why the administration took the actions they took. I think that's a slippery slope, whether you're a Republican or a Democrat. Having the Supreme Court parse out any words made by anyone within the administration within a certain area gets really scary. This is going to be readdressed. I don't know whether it will be a congressional or whether it will be an administration, but 99% of the time the Supreme Court doesn't weigh in. When they do weigh in, the Supreme Court many times takes action based upon whatever small nuance they can to say we won't address the real issue. This is one where they never addressed the real issue. They never say whether DACA was even legitimate when it was adopted by the Obama administration. They don't say whether Trump can set it aside. I'm sorry, the Trump administration can set it aside. They literally go on, they failed to follow the appropriate procedure in doing so. So this is important for you as well because as an employer, there's a lot of employers out there that are dealing with DACA. For those that don't know, these are children that came over through no fault of their own who have become assimilated in our society, and they're working, they're going to school, whatever. The message to you is this, and this is not just DACA, this is now I-9, this is H-1B visas, J-1s for anyone who is in the medical. This is a critical notice to you. You need to keep up to date with all of your employees, with all of their status, and verify legitimate status, extension of their status, and so on. Stay in tune with it because the landscape is changing every day. So that is the end of the updates. Now for the frequently asked questions, if anybody has any, or we can jump forward. I do see one about the federal unemployment. Yes, it's still scheduled to end at the end of July. So I'll answer the others as we go. And if we have others that you want to pop out now or you want to move on, you let me know, Lyle, which way you want to go.
All right. Is Allison back with us, Autumn, or are you going to help out?
I'm here.
Okay. Great.
Yeah, but do we want to go ahead and do Michelle so that we make sure we have time, or do you want me to ask some of the questions for Jim?
I'd say hit a couple of Jim's questions quickly if you can.
Okay. So we've got one about, can a test be made mandatory for anyone that returns from a specific area? So maybe Florida.
Yeah.
Protocol.
Right. So right now, the EEOC has said that you can require testing whether people travel or whether they don't travel. Clearly, hotspot areas such as New York, New Jersey, Florida, Nevada, California, any of the areas that have had either a recent spike or have never gotten to their spike, EEOC says it's fair game to test everyone before they come into work. The question we've had over the last 3 weeks is, how often can we do that? Is that every day that we can require a COVID-19 test? Obviously not. You're going to gum up the works. How often and how frequently can you do that? Once a week, once every other week? That's never really been addressed. However, what this guideline said is you can do a virus check. You cannot do an antibody check because the antibody gets too far into GINA, which is the Genetic Information Notification Act. You have privacy rights to your genetic makeup, and an antibody goes into your genetic makeup, not whether you currently have the virus. So yes, you can ramp up testing. You can determine to what level you're going to ramp it up, and keep in mind, this discussion today about a COVID-19 testing does not undo any of the governor's mandate that you continue to have ongoing testing every day. The questionnaire that the CDC or the state has recommended, the state hasn't really recommended one in Kentucky, so look to the CDC for, do you have a loss of sense of taste or taste or smell? Have you had a fever of 100.5? You still do the testing on site. Those are all examinations, but during the CDC guideline and during the pandemic, those are allowed. This discussion only deals with the COVID-19 itself.
Okay, so if, let's see, I think we can phrase this question. Does FFCRA leave protect someone whose job would otherwise be eliminated?
No. So there was a frequently asked question that came out that basically said, and we covered this right before April the 1st when the FFCRA came into effect. There was a whole lot of back and forth at that time. If you go back and listen to the webinars, there was a serious concern because everyone was firing everybody right before April 1st because that was the effective date of the FFCRA. Then they came out with a statement that said, look, if your position was eliminated, if the location is going to be closed, if your employer is not going to be able to rehire you, then you have no protection under the FFCRA. However, if you are planning on continuing operation, if there is an ongoing situation with the FFCRA, then that's a different story. I do see a question up there. Did the employee sign a non-compete in the case I'm assuming that's in Pennsylvania? The answer is yes, but the interesting thing with the contract that was signed there, that contract was if the position was eliminated through no fault of the employee, then that employee would not have enforcement. Now, the court did not really focus on that. The court actually kind of went beyond that and said, okay, let's assume position wasn't eliminated. Now, there was a huge argument between furlough and layoff or fire. And the company tried to say, well, we just furloughed. We were going to bring them back. And the court didn't take the approach I would have taken, which is who cares, because once they applied for unemployment, that means that they're fired, whether you call it furlough, whether you call it termination, whether you call it a layoff. But the court said, okay, I don't buy the furlough because your letter said we're laying everybody off or you're firing everybody. I don't know what the letter said, but they said you didn't use the word furlough. However, even assuming that you did furlough, the fact that he was unemployed in this type of situation where everybody needs a job and somebody was willing to hire him, we're going to let this person go to work. And so they went ahead and did the comparison of all the factors. And in looking at all of the factors, they decided we cannot enforce a non-compete and keep people unemployed. We're going to let this person go to a competitor who's willing to put them to work right now. So that was the import of it. Okay. Was there one other I could hammer out, or do you?
Well, is there any?
Oh, the work share. All right. First of all, I wanted to apologize because last week I made a comment about it kind of being I didn't use a curse word, but I used a word that I won't say again. But I'll just simply say this again this week. Kentucky unemployment is still broken. If you heard anything, there were thousands of people that showed up in Frankfort to try to let them know that it's broken. Yes, it is still broken. I am personally very frustrated because one of the employers that I represent that I was working to get work share, they won't respond to the work share, but believe it or not, they literally have audited one company in a retail setting where the business is literally shuttered except for trying to keep people on work share, trying to pay their legitimate portion. And now they've gotten a letter that they are going to be audited. So our unemployment department has time to audit a 3-person retail establishment forced to be closed in the medical field, where they're trying to do the best they can to continue to work with people, low-level medical, not a doctor's office, not a high-paid, but they're being audited. So the unemployment has enough time to audit people who were trying to use work share, but they don't have enough time to answer any of the work share. The official word from the attorney for the Unemployment Commission is, we don't have work share because it hasn't been adopted. I pulled out 787 KAR 1:350E and said the governor says we have work share. The governor says it's not reliant on the federal government, and that the commissioner for the Unemployment Insurance Office was mandated to issue a policy so that people could start operating, and he only had 15 days to approve people's application. It's a statewide disaster on unemployment, a statewide disaster on work share. People are getting paid that should never have gotten paid who have a job, and people who don't have a job, it's my understanding that major employers have people who have been unemployed since April and are still not getting paid. But my little employer that I'm serving as general counsel, with a total of 3 employees, with a total of no revenue coming in the door, and trying to work a part-time arrangement, they have time to audit them. So ask yourself where the priorities are. I'm very disappointed in our unemployment insurance office. I have no answers. I am very close to considering this to be a retaliatory and taking some kind of legal action to protect these companies that are being treated the way they are. I'm very disappointed because I've told you since May the 1st, I think we met on, that was signed on Friday, which was on May the 1st. I think it was May the 4th is when I showed you the regulation and said start submitting your applications. You should have had that right, and I'm sorry you didn't. And if you want to move on, Lyle, I can answer these as we continue.
Okay, great. I see another one coming in that's just a frustrating experience with unemployment for certain. But let's move on to something more positive, like how do we come out of this and take care of our employees who are having a hard time with unemployment if we bring them back to work and so forth? How do we do all that? Michelle Hollingshead, I gave her an introduction earlier. She really is a talent with helping companies make transitions, and she's given a lot of thought to what this is going to mean to us. So Michelle, take it away, and if you all have questions along the way, fire them in there. We'll be watching them, and it's just a delight to have you here, Michelle.
Thanks so much, Lyle, and thank you, Jim. I can feel, right, the level of frustration with some of the challenges that people are facing, and of course, this has an impact, right, on workplace culture, which is what I'm here to talk about today. Is how do we deal with crisis and be thoughtful as leaders and managers in supporting our people through so much uncertainty. And specifically, I'm going to share some research that's been done with 31 virtual teams about group styles, tips for managers and leaders, some very tangible things that you can be aware of and doing during this time. You'll see here, as Lyle introduced me, I'm an executive coach and culture consultant. These are my areas of expertise and my guiding principles, and I'm excited to dive in. So as we're experiencing, our world is changing faster than ever. And even before we had COVID-19, this heightened level of economic uncertainty and social change, we were already facing digital disruption. And many Fortune 500 companies that we knew of 25 to 30 years ago, I think 40 to 50% no longer even exist. And so this is the rapid pace of change, and it's not going to slow down. So the military actually in the 90s is the one who coined this term VUCA, and VUCA stands for volatile, uncertain, complex, and ambiguous. And this is really the world that we are living and doing business in. And how does this impact you as a leader or manager? Well, it requires stronger relationships and emotional bonds between leaders, managers, employees than ever before. And that's really where I focus my attention in culture, is working on the human dimension of business to support execution of strategy and sustainable results. So I want to talk a little bit now about what happens to us unconsciously when we're under high levels of stress. And this actually impacts how we communicate, how we relate to others, and build relationships. And so you can see here, this is an image of the brain. One of the fortunate things that we have in the last 10 years is so much research from neuroscience. And so much has changed since I even did my master's in education close to 30 years ago about what we understand about the possibility for change. It was believed 25 years ago that adults, really, your brain stopped, we were pretty much fully formed, and by our mid to late 20s, and that we couldn't make change. And what's happened now is with all of the MRI and the ability to take images of the brain and understand brain function, we have such a greater understanding actually of our ability to change. So I want to just highlight here the amygdala that you'll notice there toward the bottom. If you're familiar with the work of Daniel Goleman, he's considered sort of the guru grandfather of emotional intelligence. He's the one who coined this term amygdala hijack. And so just so you understand what happens when you're experiencing extreme stress, overwhelm, pressure, is the amygdala perceives a threat. And so the information coming in redirects to this primitive part of our brain. And we go into sort of the survival defense mechanisms. And I'm imagining most of you have heard of the terms, fight, flight, or freeze. And so this actually can impede, our decision making, and we can go into sort of irrational and sometimes even destructive communication patterns because the information does not make it to our prefrontal cortex. So you see that executive brain is where we actually are in our rational brain and can make our best decisions. And so you'll see here on the left some of the communication patterns that can happen when we're in this amygdala hijack can lead toward distrust. And then over here on the right, you can see some of the communication patterns that happen when we actually can be, in our normal, grounded, rational state, and the impacts that can have on trusting relationships. So if we look at the next slide, I'm going to talk about just 3 of the most common amygdala hijack triggers. And I'm sure you're going to resonate with these because I'm imagining you're experiencing them as well as your employees. And so this first one is uncertainty. And so we're just like, our system can be in an actual fight for certainty because our brain, we're actually wired more toward the negative. And so we want to try to, grasp control where we have. And so patterns like, I hope bad things don't happen, like, are bad things going to happen? And so that worry, anxiety. We also have the fight for control, which is, imagining when these things do happen, will I have the capacity to handle it and respond? And then also with so much changing and people actually learning and being required to up level and take on new skills, especially if they have to find new work, is then they can have a fight for self-worth, right? How am I going to add value? So as a leader and manager, your behavior is what sets the standard for the group norms or cultural norms and working styles in your organization. And so I want to just give you a real and tangible definition of culture because it can seem somewhat nebulous. And culture is just like, what do I need to do? What are the behaviors, the beliefs, the values that are accepted here to succeed. And it's what becomes the fabric or way of life of any organization. And so I want to propose to you that most of us are receiving messages consistently at work about what really matters at work. How do I be successful? And while we might think these messages are verbal, the majority of them are actually nonverbal. People are watching what people are doing, their actions, right? And then they start to adapt their behavior so that they fit in. And so if you see here, that culture, right? What do I need to do to be successful that people are watching begins to impact the daily performance. And so the levels where I work are typically more below the surface. And so of course we're in business because we want to be profitable. We want to have market share, right? We want satisfied customers. Those are the results that we can see above the surface. But below the surface, we each have an operating system. So if you think of yourself like a computer, right? You have certain values, beliefs, assumptions, and mental models that help drive the doing, how you're working every day. And so depending on the lens with which you're seeing the world, it's going to impact what sort of choices and behaviors you source, especially under pressure or stress. And so some of the skills that I focus on are developing communication skills, negotiation and conflict, and of course, impeccable coordination, right? How do we run high-performing teams consistently? So leaders are the ones that are setting the tone. And so I want you just to think about what is your new normal during this COVID-19 crisis? And are you feeling proud about the work of your leadership and management? And we can go ahead and look at the next slide. So one of my partners is an organization, Human Synergistics, and I use many of their assessments for both leadership and culture. And so what you're seeing here is called the circumplex. And really, their approach is that we can, have two different approaches to culture. One is constructive versus defensive. So a constructive culture is going to promote innovation. It's going to promote collaboration. It's going to promote creativity versus a defensive culture. When we're in a defensive culture, we're going to be more in protecting ourselves, defending ourselves, and actually can really get in the way of adapting, especially in times of crisis. So here, I wanted to share some really interesting research that Human Synergistics did with 31 virtual teams, and they did a group styles inventory to understand what sort of culture starts to happen when people work only virtually, and specifically around solving problems. And so you'll notice here, ideally, we would want to see from effective culture, we would want to see the constructive, the blue, above the 50th percentile. But you'll see here, from 31 virtual teams reporting, those actually more constructive styles started to diminish, and the passive and aggressive defensive behaviors started to extend working virtually. And so super important, right? Because many of you, I imagine, are still leading virtual teams as we start to make our way back into the actual workplace. And so I want to tell you a little bit about what they saw here, and why did they see this? And so if we have the heightened defensiveness, it was due partly to the lack of nonverbal cues and the negative aspects of de-individualization, such as feelings of people feeling isolated and perceived lack of accountability that was promoted by technology. Versus a constructive team would be doing things where they're going to interact and approach problems and activities that help them focus on both interpersonal and performance related needs. One of the other things that they mentioned was when we're working virtually, people can feel more insecure, or what they call psychologically unsafe. And if we look at the next slide, I highly recommend, if you are not familiar with the work of Amy Edmondson out of Harvard Business School, she is the one who coined the term psychological safety. She has a phenomenal TED Talk with her actual research in healthcare on psychological safety. It's 11 minutes. I would recommend that you check it out. How she describes psychological safety is it's a belief that you will not be punished at work or humiliated for speaking up with ideas, questions, concerns, or mistakes. And as you know, with the level of complexity of business challenges we're facing, we need to leverage all of the strengths and talent of every member of our team. So I'm going to talk to you a little bit next about what you as a manager or leader can do. And these are just sort of some quick tips to keep in mind. So the first thing that I would recommend is check-in. And what a check-in is it's, you know, sort of checking in with yourself. How am I doing really? If you're not able to be connected to how you're doing, you're not going to be able to connect very well with how your people are doing. So especially, you know, with the waves of what I described of what you might experience during crisis, you need to be able to regulate yourself, right? And that's the next one. If you're not aware of sort of what's happening for you and how those might impact you choosing defensive or aggressive behaviors, it's going to be really difficult to help your people do that. So the second is, after you're able to do that for yourself, you know, it's really important, especially now during crisis, to be able to connect with people on a human level to understand how your team members are doing. And so one of the things that I teach is these 3 C's: connection, before context, before content. So we always, you know, try to do a little bit of the connection at the human level before moving into the context of a meeting or the content. And so, you know, a 5-minute check-in just to get a pulse on, you know, where people are at is really important. The third recommendation is being seen. So if you have access to video conferencing technology, use it, because that is the great thing of technology. If I can see you, I have a better chance of reading those verbal cues that I talked about, right? And being able to see your responses to things. And encourage your people to come on the video. This is a new skill that a new muscle that has to be developed, probably for yourself and others. And the fourth here is come back to a unified sense of purpose. Business really, really can be a force for good. And when we can remind people about the service that we're offering in the marketplace, people can reconnect to feeling like they're doing something meaningful that's valuable. Meanwhile, we also need to keep objectives realistic during crisis. I heard initially some teams or organizations, it was like, let's just start, you know, layering on a whole lot of extra stuff because people were kind of in this, you know, panicked mode or thinking we don't have enough to do, let's do all of this. So, you know, it's just important to keep a balance and you know, keep the main priorities still the main priorities. And the next recommendation is being willing to adjust and adapt as new information is available. Just like Jim was providing, right? There's a lot of things that are changing and shifting so quickly. So there's a lot to stay up on that, which may impact, right, some of the decisions that you're making, and being willing to go back to the team and say, okay, here's the new information. Here is why, you know, we're adjusting and adapting based on, you know, these changes in regulations, etc. Because it is easy, like I said, in the virtual environment for maybe people on your team to be more quiet on calls or to go into more of this, you know, survival mode, you're going to have to encourage discussion and really request alternative perspectives to stimulate thinking. This is especially important if you're problem solving. So one of the things as a leader that you can do is say, I know that even with all my knowledge, I can't possibly have all of the answers. I need to hear from everybody on the team, maybe even do a round of turn taking so that people that are more introverted, right, they know there's an expectation for them to also contribute. The next one is highlighting job significance, reminding people about the importance of their job and how it actually adds value is you know, really helpful for people staying engaged and seeing that they're making a difference. And then the last two relate to feedback, and it's really important as the leader or manager that you're establishing feedback loops, especially when you might not be seeing people as often, right, that you would pass in the you know, in the break room or just in the hallway. And so one of the ways you can do this is building that into a meeting where, you ask specifically and say, I'm going to open up time and I want to hear your feedback, whether this is in one-on-one check-ins or team check-ins, to make sure that you're opening up and not waiting for people to come to you, but you're requesting and saying, how's this working? What's working? What's not working? And then the last one, the research from the American Training Society used to be on feedback. It was 3-to-1, but it's now 5-to-1. And what this means is we need to give 5 constructive, appreciative feedback for one where it's more critical or redirective. So not taking people for granted and really calling out very specific things that they do and appreciating those can go a tremendous, you'd be surprised at how much it can do to keep people motivated and engaged. I think we might have a couple of questions, not sure, so let me check there with Autumn. Or Allison, sorry, Allison, maybe.
No, it looks like most of the questions that have come in are follow-ups on legal.
Perfect, so let's pass it back over to Jim.
Thank you, Michelle. I appreciate that.
Yes, thank you. That was great.
And yeah, Jim, you want to respond to any of those notes that came in?
Sure. So I am actually I've been answering most of them. If anybody wants to throw some more out there, I was just trying to find the case. Let me go back to that really quick, if you don't mind. I got a question about the Pennsylvania case, which I would assume will create some problems. So the case, if anybody wants to look it up, I was trying to pull it so that I could dump it into the chat, but then you threw it back to me. So give me just a second, and I'm going to try to put that on the screen. But if you see what's up there now, the case name is this one right here. It's I'm not going to try to pronounce that. It looks like Schuylkill Valley Sports versus Corporate Images, and that's you can pull it up yourself with a Google search, and then I was going to try to find, here's the detailed information. The case is actually, it's 5: I'll just pull it over there. I don't have the actual order in front of me, I apologize, but here is the case. Whoops, it's not on the screen, sorry. Here's the case, if you want to pull it up for yourself so that you can actually see the actual details instead of relying on my synopsis of it. I would suspect that you're going to see a lot more cases like that coming out shortly. And so that's just a precursor of what we're going to have in, wow, I've gotten like all kinds of people saying it's Schuylkill. So, sorry. I got like all kinds of private messages saying, hey, dummy, this is how. So that's the update on that particular case. And if there's any other, I can answer the one. Yes, the slides are available after, and so is the video. And that way you can actually pull it up,
on Hanna Resource,
look through everything that you have.
Website. Yeah, they're on HannaResource.com.
Yeah, they're on. I think they're both. We usually post them on the Morris & Morris one too, so you can pull them up on Hanna. You can link back and forth. We've tried to make these all really quickly available to everybody. And I mean, there are other updates. I try every week to mix them up, but we try to make sure that we keep things fresh with new types of information and what's going on. But the Supreme Court, when they rule on a employer-based issue, we thought you all should know what that's about. And I see that David has a question for Michelle, maybe, that he's starting to type in. So I'm going to throw it back to her.
Thank you. Got it.
Or Chase, maybe you could just turn David on for a minute, so to speak.
Oh, here's a question.
Okay. Any suggestion for new tools on providing feedback in this virtual world, moving from documented formats? Well, so that's a great question, David. I know some teams do have, tools like Slack and stuff where or Microsoft Teams where they actually can do this virtually. My concern would be if you are going to provide feedback, though, that is not an appreciation or just it is more of a corrective feedback, that would be done verbally, because that's where assumptions can be made. And so I would recommend doing that on a video conference so you can see the person and make sure that there's room for them to ask questions and have examples ready, right? So you can kind of coach them through that. Now, if it's, I think it's great to use virtual tools like text or, if you have online team platforms for the positives. So that would be my recommendation there.
All right, Michelle, thank you so much for joining us today. And Jim, as always, you did a great job and appreciate your covering all this ground. And man, we did this in about an hour. How about that? We put the last slide up because we're still getting SHRM credit. There's a code there, and HRCI credit for today's participation. Thank you all so very much. Anything else popping in, Allison? Looks like we're clear.
I haven't seen any other questions.
What's that?
I said we haven't seen any other questions.
Yeah. Okay. Well, we're standing by this week. If people need us, don't hesitate to reach out. We hope you have a great week. I'm keeping my hope up and plan on having a great week. So, Rita Johnson, thank you so much too for joining us all the way from E-Town. Everybody hang in there and have a great week. Thanks a lot. It's Lyle, Hanna, and HRD Morse and Morse signing off.
Thank you.
Bye-bye.
Bye.